Get any water today, huh? Computer shutting down for some reason. You didn't print it with this. It's my computer shutting down. All right. I received proposals from both sides. Have you reviewed each other's proposal?
Not thoroughly, Your Honor. We have one copy and are passing around this.
Put the caption up there too. The caption.
I'm ready, Your Honor. If you're ready.
All right. It says the state.
Your Honor, I'll address the defense's request in conjunction with ours. As to the first question, we have no objection to the first sentence of the defense proposal. It is a lesser offense of murder and you may consider it. The question the jury asked was why, not necessarily what, and I think it goes to a reemphasis of your role versus their role. And I think you should describe to them as we have suggested what your role is, and that is the court's duty is to instruct you on the law that applies to this case. You should not concern yourself with the origins or the law. Your oath requires you to accept the law as instructed to you. As I instructed to you, and it is available and applies to this case. So again, that's sort of, because the question was why, not what, I think it's important for you to talk again about your roles. As to the second defense response, we believe that it is on the right track. It stopped short, and we would ask that you include with theirs our last paragraph, which was in our original request and our request Friday, that says sufficient legal provocation is a provocation which you may determine induced heat of passion under the law, an overt threatening act by the victim may, if you so decide, constitute sufficient legal provocation. A person's fear immediately following an attack or threatening act may, under the law, cause the person to act in the sudden heat of passion if you so determine. And that's from the Starnes case. As for the third group of questions regarding imminent danger, we supplied you with what is in essence the Black's Law Dictionary definition of imminent danger. As to the fourth question regarding what is a forethought, we proposed language that is very similar to what you've already proposed or already charged, but just stated maybe slightly in a different way. A forethought means just before and at the time of. A forethought need not exist for any appreciable period of time before the commission of the act. Indeed, it may be conceived at the very moment the fatal blow is given. That's from Kynard and Milam. As for the defense proposal number 5, we oppose that as we discussed prior to the break. They have given you a Graham v. Connor quote. The court's already ruled on that. Our proposal is much simpler and I believe correctly states the law, as you have stated, that the law of self-defense is available for any reasonably prudent person of ordinary firmness and courage. There's only one law of self-defense, and it has been charged to you. We have no objection to the defense's number 6 regarding taking all of your instructions as a whole.
Says the defense.
Thank you, Your Honor. May it please the court.
Yes, sir.
We have no objection to state's number 1, so we'll go along with that. If that's what you want to do, unless you have something else. With regard to question 2, we don't see the real difference between what they can actually do in question 2 and just telling them to follow your written instructions. The state has gone back to this notion of fear and heat of passion, which is expressed and not what they asked you about. The only thing they've asked us about, the question they asked us is sufficient legal, what does sufficient legal provocation mean and who does it apply to? So we think our charge is more directly at that point than going back into heat of passion and fear, which they expressed and did not ask about. So we would ask the court either to give our number 2, which refers them back to yours as well, and just tell them to read your charge again, which we've read again in Lynn and think is clear. But to go back into abbreviated, the state's version is a very abbreviated version of the original charge. If you do anything, give that again, or give ours, because it just directs the jury to sufficient legal provocation and answers their question. Imminent danger, they cited Black's Law Dictionary. Once again, we read over and over the original charge on this, on self-defense, and where it came from, and I can't imagine what the difficulty is there or how Black's Law Dictionary changed it. So once again,
What is imminent danger?
well, we've asked you, we think you're charged.
So I'm asking you to tell me what I've said. What is it?
It's well, Your Honor, if you're taking all the circumstances into account, it's something that happens here about the same time that you use deadly force. And, the evidence in this case, as I understand it, you're talking about a matter of 4 seconds. So, that's part of the issue. I think what the jury's done, I think they know what evidence it is. With all due respect, we think that they do. We think that they're trying to enlist the court's help in, resolving the time frame. That's a difficult question. It's just a difficult question, and I don't think that Blacks helps them any more than your original charge. That's just our position.
So you don't believe I should define imminent danger?
Well, we believe your charge, if you had it adequate. That's our position.
Well, the charge says that the defendant was actually in imminent danger or reason to believe that he was, but it doesn't describe what imminent danger is. And their request is what is meant by imminent danger.
Then I think if the court is leaning toward giving some definition, you must ask the jury to take into account all the facts and circumstances surrounding the incident at the time deadly force was used. Because they've got to get a time frame.
Well, the state says only that they found a definition in Black's Law Dictionary. Now, in the annals of South Carolina law, is there any other definition of imminent danger? And if not, then
I'm not specifically aware of one, in the court's adopted Black Law Dictionary. I think, a few days ago, the state was willing to let people use terms in the ordinary and plain meaning. And maybe that's what the court would charge about imminent danger. But I think you've got to tell them that they have to take all, with respect, all the facts and circumstances of the account into account, and then maybe add the state's language to it. Because otherwise, I don't know what, it's much clearer to say immediate danger. And if they don't understand the imminent, I don't know what immediate means and so forth. So, and in addition, this goes right squarely to question 3 to the law of appearances, which the court may also want to reemphasize. We've handled that later in our request. But I don't see that this clarifies matters over and above what you've written in charge. And again, we'd ask the court, if you charge something along the state's lines, that you indicate they take all the facts and circumstances of the account into account in judging the time, in judging imminence, and judging immediate, however they choose to do that. Malice of forethought, give me one moment, please, Your Honor. And again, again, we don't think this is different from your original charge. We don't see how that adds to it, and perhaps the court just needs to read it carefully and direct their attention to that. On self-defense, question number 5. Of course, it usually does a difference. That's why we put the language from Connor in here. I'm not going to argue that again with the court. I just think we also cited State v. Fuller. It doesn't say that. It doesn't. But in terms of the law of appearances, we think that as you charge the law of appearances, it is relevant that one is a police officer. There has to be some support in the state, not directly, based on law of appearances in Fuller, that if one is a police officer acting in the hurried business, of pursuing someone and trying to calculate what to do and making split-second judgments, there's actually a basis for the Connor language that we think in the appearance charge, in the appearances, the law of appearances case, not just in Connor alone, in terms of how one acts and the speed with which one acts. Maybe if you don't charge Connor, you should charge the law of appearances, at least direct their attention to it. And I understand that the state has no objection to our number 6. There's a typo there. It says these instructions which I have just given you should not be read to contradict the previous instructions you were given at the beginning of your deliberations. These instructions should be read in conjunction with and consistent with the instructions previously given. All the instructions should be taken as a whole. So they haven't really objected to that, so we certainly ask for that. The only other addition I would make is number 7, which is not here, is that you recharge beyond the burden of proof, reasonable doubt, and the presumption of innocence, or direct their attention to it with the charges, the written charges that you give them.
Well, since the Fuller case occurred in 1986, the instructions regarding self-defense has evolved quite a bit, and it's pretty much evolved into the standard instructions that was given. Fully occurred at a nightclub on Two Notch Road in Columbia, where the victim, Dixon, went in his car, and Fuller thought he was going to get a gun or something and shot and killed him. And the appellate courts ruled that the court was erred in not charging that Fuller had a right to act on appearances, since he believed that he was going to get a gun. So the principle of Fuller has been incorporated into our law and was already instructed to the jury. What says the state?
Your Honor, first of all, regarding the Black's Law rendition that we proposed to the court, State v. Harris is a South Carolina Supreme Court case, 340 SC 59. It's a 2000 case that talks about juror misconduct when a juror went to a dictionary to look for the meaning of words. And so while it's addressing the misconduct of a juror doing independent research, it does discuss the fact that there is no prohibition to courts looking to dictionaries when the dictionary definition does not contradict what our law is. So the jury has asked specifically about imminent danger, and we believe the definition that we supplied supplements what you've already instructed the jury, but doesn't contradict it or replace it. So we would ask that you go along with our regarding the second question. I believe it would be incomplete to talk about sufficient legal provocation without talking about heat of passion. I note that the jury did ask a specific question regarding heat of passion, regarding fear on Friday, which was not addressed. And we believe that a full and complete instruction regarding voluntary manslaughter and these two principles, again, is restating what the court has instructed, but doing so in a slightly different manner to give a more full and complete instruction. So we would ask that you include the language from Starnes and from Smith and give those to the jury together.
All right. Anything else?
Yes, sir.
One just a brief thing. You were asking about the definition of imminent, and
Yes, sir.
I overlooked a passage in your instructions, which might, the original instructions, which might be highlighted in the jury, which I think does define it. It says, I don't have a page number, so it's in the context of self-defense. The passage is, if the defendant was actually in imminent danger, it must be shown that the circumstances which have warranted a person of ordinary firmness and courage to strike the fatal blow to prevent death or serious bodily harm. So it seems like to me maybe that should be charged to the jury, or they should be reminded at least of that. Because that kind of puts some flesh on the bones of them. That's what a reasonable person of ordinary firmness and courage have done in that circumstance, which was kind of what I brought up before, but you got it here. Then with respect to voluntary, I understand what the state is saying, but they're going beyond to a question last week, which wasn't asked this week, in which we've already resolved, and they're changing your charge substantially rather than focusing on sufficient legal provocation.
I'm going to merge the requests of both sides into a single charge, except that I am not going to charge, which I've already rejected, which is the civil case, Graham v. Connor. I think Fuller is already included in what was given. So essentially, I'm going to give what everyone requests, except for Graham v. Fuller, and I'm going to put it merge it into a single instruction.
Thank you, Your Honor.
And I'll take a few moments to do that, and then we'll deal with the jury. After that, so we'll take about 10 minutes and then we'll bring them out.
Thank you, Judge.